Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale, a real-life case with real-life clients and real-life facts, though names are altered for confidentiality purposes. There are times that in the conference room with clients, I'll share crazy stories and they'll say, Jenny, you need to write a book. And now I can say, well, what about my podcast? I've got a podcast where I blab about stories on there. And today's topic reminds me of one of those crazy stories that I've told to clients, that it's so loony that I sometimes think clients wonder if I totally have made up these stories in my head. And they may be in my head like as a memory, but they're certainly not made up. So let's get down to business for our cautionary tale. Alrighty, one day a paralegal grabbed me because she had just taken a really weird call and wanted to make sure we could even help the prospective client. I was like, okay, lay it on me, what's going on? She proceeds to tell me that the person on the phone shared that their family member passed away. They had an estate plan and specifically a trust, that assets are held inside the name of the trust, but no one can find the trust document. They've searched high and low, and it's nowhere to be found. So that was a first. I had never heard of that happening before. Granted, it's obviously very possible that the estate plan is totally missing, but I have never had to work on a case that had this issue. So I had reached out to my office's former owner to see if she had ever run across something like it, thinking, well, she practiced for nearly 30 years. Surely she's seen this. Nope, she hadn't either. So I remember thinking, well, I guess I'm heading to do some research. As I got deeper into the research, I started figuring out what needed to be done, which we'll get to in a little bit. But before I really developed a plan of attack, I needed some more information from the prospective client so I could make their upcoming first meeting super productive. Mainly, I needed to know who was involved, like family member-wise, as well as asking for them to send me some documentation showing what assets were actually held inside of the trust. So whether it was a property or a bank account, in this case, there were, I believe, a couple annuities. So after I gathered family information and the caller sent me some documentation, I started connecting the dots. So let's see if you can hang with me on this one. The trust was actually the caller's grandmother's trust, and the grandmother had passed away over 10 years ago, specifically in 2008. The grandmother had one child who was the caller's dad. So the caller's dad passed away this year in 2021, and the caller was administering her father's estate when she located the assets that were held in her grandmother's trust. So let's do it like this for my more visual listeners. Think of grandma at the very top. She passed away in the early 2000s. Grandma had the one child who passed away in 2021. And imagine him as sort of like the second tier. And then the final and third tier represents the grandmother's child's children. And that was the caller, and the caller had 3 siblings. So 4 of them on that last tier. I have worked a case where the top tier person passed and the second tier person passed. And the top tier had a house in their name that never got transitioned to the second tier. So the third tier asked me to help them get it from the top tier to them. But the difference here between that and this case is the people that had passed away in my prior case I worked on, they didn't have an estate plan at all. No will, nothing. So we just went by the intestacy statutes. We opened an estate in that top tier person's name, and we opened an estate in that second tier person's name. So we transferred the house from the top tier person's estate to the second tier person's estate, then transfer the house from the second tier person's estate down to the third tier in those intestate beneficiaries. But here, with this case, there was a governing estate plan, a trust nonetheless, and the thing that was supposed to govern assets was missing, lost, couldn't be found. So I had done my research and I was ready for the meeting with the prospect. And I remember telling my coworker and fellow attorney who was joining me for the meeting that I hoped the prospect was a reasonable person, because there was going to be a legal process that we'd have to go through, and it wasn't going to be easy, and it wasn't going to be fun, but it was the most appropriate course of action. So fast forward a little bit. Thankfully, the prospect was super reasonable and understood. So, The financial institution that was actually holding the assets inside Grandma's trust stated they needed something showing that the granddaughter, the one that was calling, was now the trustee of Grandma's trust. The issue with that sentence is that it totally minimizes the appropriate process. I think the caller thought I could just whip up a document that states, okay, well now this person is the successor trustee and things are fine and dandy. But if I did that, I would be taking on liability. What if Grandma's trust put a bank as a corporate trustee? And the bank should have earned compensation serving in that role or something. So who knows? The dang document's missing. So as I explained to the granddaughter, I just can't willy-nilly appoint someone. I feel like I'm a powerful person, maybe in my own head. I'm not that powerful. Attorneys have a lot of power in the legal system, but they don't have that much power. So really at this point, this is what I shared with her, I firmly believe that the only person that has the authority to appoint a successor trustee, since we don't have the trust document, would be to involve the court and have the judge appoint who's going to be the trustee. Annoying? Yes, for the family. Cumbersome? Yes. But was it the best solution? Yes. I proposed to the granddaughter that we do two things. That first, we get an estate opened for Grandma. And once the estate is opened for Grandma, we ask the court to make the trust assets payable to Grandma's estate. After all my research, there may have been other ways to do it, maybe easier ways. But what I was most concerned about was the liability on the family, and specifically the granddaughter. What if the trust gets found 20 years later somehow, some way, and the trust beneficiary was a church, a charity, someone else besides the family? Likely? Maybe not. Possible? Yes. I told the granddaughter that there are probably some ways that could have been, easier, would have been cheaper. We could have just thrown together an agreement between all the parties, kept the court out of the picture. But if it were my family, this is the path I would recommend. You see, as much as I don't like getting the court involved, here there are two advantages in doing so. First, part of the probate process is to publish notice of the estate to the world. In a newspaper, that's where they're most commonly done. So what does that mean? Going through a more formal process will start tolling the statute of limitations on anyone that would try to kick up a fuss later. As in, say in my example earlier, what if Grandma did put her church as her trust beneficiary and they happened to find a copy of her trust? Ideally, the statute of limitations is told, and they would essentially be SOL, beep, out of luck. Second, running it through the court will keep things cleaner between Grandma's estate, then paying her son's estate, then the son's estate paying the son's 4 children. Because the court is involved and me, the attorney, is involved, things will be kept on kind of the up and up more to again make sure everyone is on the same page. Not to mention, we'll have court orders to provide to the financial institutions to force them to comply. Again, it's a cleanliness thing. So that's what we did. The client, good client, listened to my recommendation. After all, she didn't have to. She could have said, Jenny, I hear you, but I think we're just going to do the cheap and easy option and have you do just an agreement between all of us. Honestly, if they chose that, I would have instantly started papering the heck out of my file for them. For example, I recommended they do Y and they chose to do Z. That would all be protecting me. That way, if anything did happen in the future, they couldn't come back on me. But thankfully, she recognized that the involvement of the court here was actually a good thing. It formalized things, and it ultimately gave the family peace of mind knowing that finally, after the many years since Grandma passed, T's were finally crossed and I's were dotted. So when it's time for you to #do your estate plan, let's be sure it does not get lost. There are a few things that you can do after your estate plan is created to ensure your family is not in a boat like these people. So let's talk about them. First, put your documents in a safe place, but also put them in a place that is sort of intuitive for your family, especially if you choose not to tell your family where you're putting your documents. For example, I remember my own grandparents used to put important stuff in their freezer. I'd reach in to get like an ice cream bar and some important piece of mail would fall out. So don't put your estate plan in your freezer, okay? Or any other silly place equivalent to a freezer. I hope my mom listens to this episode and catches that little snippet for her parents. Oftentimes, I actually recommend a fireproof safe. The investment in something like that will be worth it. Along those same lines, I do not recommend a safety deposit box at a bank. Banks get really weird when people die, and oftentimes they don't let the family access the box. Second, perhaps make digital versions of your documents and store them safely on your computer. P.S. If this route is a thing for you, do make sure your family knows how to get on and log into your computer if you were to pass away. My office maintains a hard copy of clients' documents and a digital version too. And sometimes when I explain this to clients, they'll say, hey, can you send me the digital versions as well? So just ask your attorney to see if that's an option and if they're willing and able to do that for you. Third, giving copies of your documents to your kind of first people in charge, it's both a good and a bad thing. It just depends on your kind of family and openness of this conversation. It's a good thing. It's a good thing because, of course, they have a copy of your documents if something were to happen to you, your originals. It's sometimes bad, though, because if you were ever to update your documents at any point, you'd have to remember who has copies of your documents and make sure they get kind of new ones replaced. The old ones replaced with new ones. The last thing you want is to give someone a copy, you update them, not give them the updated version, and they inadvertently operate by outdated versions. That's not good. The thing is that Indiana, at least, does not require attorneys or people to submit their documents to court and record them with the state. If I tried to walk into the courthouse to record a client's will or trust while they're still living, the court staff would be like, have you lost your mind, Jenny? Sometimes, like in this client situation, I wish states would require us to file or record it. But I'm sure it would be such a logistical nightmare to manage, so maybe that's why they don't do it. Sometimes after people pass away, their documents get filed with the court, but not while they're living. So knowing this, be sure to make appropriate arrangements in your life when you #do your estate plan. That way, you don't end up as a legal tea cautionary tale. Next week's topic is a current trend, a current event, something I've seen or run across that I think would be interesting on here. So for next week, we're actually going to be talking about the Indiana Supreme Court upholding a woman's estate plan, specifically after she passed away, that made her adult son's inheritance dependent on whether he was married. And in the past, that has been considered a no-no for public policy reasons. So we'll talk about that next time, that case next time. Until then, Legal Tea listeners, be well.